Good morning, students. In the last class, we discussed the transfer of ownership. So, what is an ownership, or on what basis the ownership is to be done? Like, it should be in the transfer of the possession of the thing and also transfer of the property of the things. Okay. So, transfer of property and transfer of possession, that is the two things. ഒന്ന് ഉടമസ്ഥാവകാശവും മറ്റൊന്ന് കൈവശാവകാശവും. Okay. So, then we see what are the main rules with regard to, or on what basis this transfer is to be done. Maybe on the case of ascertained goods or specific goods. Another one is on the basis of the unascertained goods, and also on the basis of the sale itself. So we will look into that once again. So we see transfer of property and transfer of possession of the goods in the last class. Then we see significance of the transfer of ownership, that is, risk prima facie passes with the ownership, the action against the third party, insolvency of the seller or the buyer, or to file a suit against the buyer regarding by the seller. These are the points with regard to the transfer of ownership. Next, we see then in the previous class, we see more this one, the rules regarding the transfer of ownership, where goods must be the ascertained one. Then intention, it must be between the intention of the, or with the intention of the parties. Both the parties may be buyer as well as the seller. And then what are specific goods or ascertained goods, or the rules relating to the specific transfer of property in case of specific goods are, it is when the goods are on a deliverable status, or when the goods are to be put on a deliverable status. Okay, or the third case is what? Goods have been to be weighed or measured in order to ascertain the price. And the value kanakakkan vendita, goods need to be weighed or measured. These are the case with regard to the ascertained or specific goods. While unascertained goods are goods must be ascertained. Transfer of property in ascertained goods, it must be ascertained, and it must be in a deliverable way or status, so that it can be unconditionally appropriated and the goods sold on approval or on sale or return basis. These are the case with regard to unascertained goods, means the value is not ascertained. Then in case it should be ascertained, അത് ascertained ആക്കണം, എന്നാലേ അതൊരു ട്രാൻസ്ഫറബിൾ ആകാൻ പറ്റുള്ളൂ, ഓണർഷിപ്പ് ട്രാൻസ്ഫറബിൾ ആക്കാനായിട്ട് പറ്റുള്ളൂ. അതാണ് നമ്മൾ കണ്ടത്. Then today we are going to see what is a sale by non-owners. Sale by non-owners. So what is that? The general rule regarding the passing of ownership or the rights is that no one can transfer the right which he himself does not have. അവനവനുള്ള അവകാശമേ അവനവൻ ട്രാൻസ്ഫർ ചെയ്യുള്ളൂ, അതാ പറഞ്ഞു. So no one can transfer the rights which he himself does not have. അവനവന് ഓണർഷിപ്പ് ഉണ്ടെങ്കിൽ മാത്രമേ എന്ത് ചെയ്യുള്ളൂ, ഇറ്റ് ക്യാൻ ബി ട്രാൻസ്ഫേർഡ്, otherwise no. Okay, so the general rule regarding the passing of ownership or the rights is that no one can transfer the rights which he himself does not have. This principle is carried in the Latin maxim nemodat quod non habet. Nemodat quod ഒരു ലാറ്റിൻ ഇതാണ്, nemodat. It is called non-habet. Latin word. Okay. Thus, another example കൂടിയാണ് പറഞ്ഞിരിക്കുന്നത്. If a ring belonging to A is stolen by B and sold to C, so what is that? A ring. Actual owner is A. That is to be, what is that? Stolen by B and sold to C. Oh, actual order is what? A. B is stolen that thing from A and sold to C. C will not get any title on that commodity because the actual owner is from A. Okay, actual order A ഉള്ളിടത്തോളം കാലം in the C will not get any title to that particular ring. So A shall continue to be the owner of that ring even if the possession is with C. Because possession now with whom? C. കൈവശം വെക്കാൻ ആർക്കുണ്ട്? C. Because now the ring is with the C. Because B is stolen from A and sold it to C. So C having the possession, but the actual ownership vested with the whom? A. So that is the case sale by non-owners. Means if he has the right, then only he can pass it. If he doesn't have the right, he can't pass it anything. So C is not having the right of ownership because the actual owner is still alive to A. Isn't it? So, thus if a ring belonging to A is stolen by B and sold to C, C will not get any title on that commodity as A shall continue to be the owner of that ring even if the possession is with C. This principle is reflected in section 27, which provides that where goods are sold by a person who is not the owner and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods than the seller had. Actually, who is the owner? A. Who is the buyer here? C. Even though he is, what is that? Goods are sold by a person. Means B is selling that thing to C, okay, who is not the owner thereof and who does not sell them under his authority. B is not having the authority to sell that particular ring to C or with the consent of the owner. Aയുടെ consent ഇല്ല കാര്യം അത് മോഷ്ടിക്കപ്പെട്ട ഐറ്റമാണ്. Okay, so there is no consent with the original owner and also B is not having the authority to sold it. Then the buyer, the C, doesn't have the title to acquire that one. Okay. However, this rule is subject to certain exceptions also. അപ്പോൾ ഇവിടെ ഇതാണ് പറഞ്ഞു വരുന്നത് നോൺ ഓണർ ആരാണ്? ഒറിജിനൽ ഓണർ ആരാണ്? എ ആണ്. പക്ഷെ ഇപ്പൊ ആരാ കൈവശം വെക്കുന്നത്? സിയിലാണ്. ഓക്കെ, അപ്പൊ ഇതാണ് ഓർക്കേണ്ടത്. സെയിൽ ബൈ നോ ഓണേഴ്സ് എന്ന് പറഞ്ഞാൽ അവരുടെ ഉള്ളിൽ അവരുടേതായ റൈറ്റ് അവർക്ക് അത് ചെയ്യാനുണ്ടെങ്കിൽ ചെയ്യാം, ഇല്ലെങ്കിൽ പറ്റില്ല. അതാണ് പറഞ്ഞത്. സോ the general rule regarding the passing of ownership or rights is that no one can transfer this right which he himself does not have. This principle is carried in the Latin maxim "Nemodat quod non habet." Therefore, if a ring is to be stolen by B from A, who is the original owner, and sold it to C, then actually he is the original owner of that ring, even if the ring is to be possessed by who? C. This principle which provides that where the goods sold by a person who is sold, B is selling, okay, who is not the owner and who does not have the authority vested with him to sold, isn't it? Yes, so C ക്ക് കൊടുത്താൽ പിന്നെ ഉണ്ടായിരുന്ന കാര്യം it is with the consent of A, isn't it? So അതാണ് കേസ്. Who is not the owner and who does not sell them under the authority or with the consent of the owner, then the buyer acquires no better title to the goods than the seller. വിൽക്കുന്ന ആളെക്കാട്ടും ബയർക്ക് there is no particular title with regard to that goods because the original ownership is with the who? A, not C or B. B is the seller. സെല്ലർക്ക് ഇതിനകത്ത് ഒന്നും ചെയ്യാനില്ല, കാരണം സെല്ലർക്ക് വിൽക്കുന്നതെന്നേ ഉള്ളൂ. ഒറിജിനൽ ഓണർ എ ആണ്. എയുടെ കൺസെന്റ് ഉണ്ടെങ്കിൽ മാത്രമേ സിക്ക് അത് ഓണർഷിപ്പ് പാസ് ചെയ്യാൻ പറ്റുള്ളൂ. ബിക്കോസ് ഒറിജിനൽ ഓണർ ഡസന്റ് നോ ദാറ്റ് ദിസ് ഈസ് ദ തിങ്. ഇതാണ് ഓക്കർ ചെയ്തിരിക്കുന്നതെന്ന് ഒറിജിനൽ ഓണർക്ക് മനസ്സിലായിട്ടില്ല. അല്ലെങ്കിൽ അയാളുടെ കൺസെന്റ് ഉണ്ടെങ്കിൽ ഓക്കെ, ക്ലിയർ. There are some exceptions to this rule. Nemodat quod non habet. One is the title by Estoppel. What is that? We will check it. That there are some exceptions to this cases. Means ഈ ഒരു അതോറിറ്റി വെസ്റ്റഡ് ചെയ്തിട്ടുണ്ടെങ്കിൽ അല്ലെങ്കിൽ റെസ്പോൺസിബിലിറ്റി ഉണ്ടെങ്കിൽ അതോറിറ്റി പാസ് ചെയ്തിട്ടുണ്ടെങ്കിൽ he is having the right, then okay, otherwise no. അതാണ് നോക്കേണ്ടത്. So exception to this rule, one is title by Estoppel. So what is the title by Estoppel? Where the owner by his conduct or by an act or omission leads the buyer to believe that the seller has the authority to sell and induces the buyer to buy the goods, he shall be stopped from denying the fact of want of authority of the seller. So, how it is that where the owner, ഒറിജിനൽ ഓണർ ആണ് എന്ന് അവരുടെ അയാളുടെ പെരുമാറ്റം അല്ലെ പ്രവൃത്തി ഒക്കെ കൂടെ കണ്ടിട്ട് leads the buyer to believe, വിശ്വസിപ്പിക്കുന്നു ബയറിനെ, so that the seller has the authority to sell and induces the buyer to buy the goods, then he shall be stopped from denying the fact of want of authority of the seller. സെല്ലർക്ക് അതിനുള്ള അധികാരമുണ്ട് എന്നുള്ള ആ ഒരു തോന്നല് who is having, the buyer is having, because based on the act or the conduct done by who, this person, who, this seller. So that where the owner by his conduct or by an act or omission leads the buyer to believe that the seller has the authority to sell and induces the buyer to buy the goods, he shall be stopped from denying the fact of the want of the authority of the seller. The buyer in such a case gets a better title than that of a seller. For example, A says to B in the presence of C that he is the owner of these goods. Then C does not contradict A's statement. അതായത് ഒറിജിനൽ ഓണർ ആരാണ്? സി ആണ് ഒറിജിനൽ ഓണർ. Okay, A is there, B is there. So A is saying to B that in the presence of C, okay, in the presence of C, A is telling to B that he is the original owner. A പറയുന്നു സിയുടെ മുന്നേ that A is the owner for that goods. Actually, who is the original owner? C. But C is nothing saying about this. That is no contradict statement. എതിർത്തൊന്നും പറയുന്നില്ല. Then C does not contradict A's statement. Subsequently, B buys that goods from A also. A ഇന്ന് B ആ സാധനം വാങ്ങിച്ചു. കാരണം A പറഞ്ഞ എന്താണ്? ഞാനാണ് ഇതിന്റെ ഉടമസ്ഥൻ. ആക്ച്വലി ഉടമസ്ഥൻ ആരാണ്? സി ആണ്. സി അത് എതിർക്കുന്നുമില്ല. അപ്പോ B buys the goods from A. Therefore, C cannot recover the goods from B since he has led B to believe that A is the owner of the goods. C cannot recover from the goods from B because C പറയുന്നില്ല. C അതേസമയം എന്തെങ്കിലും ഒന്ന് പറയുകയാണ് that I am the owner, original owner എന്ന് പറയുകയാണെങ്കിൽ then it is okay. Otherwise, C cannot recover anything from those goods. Okay, C cannot recover anything from those goods that is to be acquired by B since he has led B to believe that A is the owner of the goods. കാരണം ബിയുടെ ബേസ് ഇതില് in front of B, who is the original owner, not C, A. അപ്പം A തെറ്റിദ്ധരിപ്പിക്കപ്പെടുകയാണ് അല്ലെങ്കിൽ B തെറ്റിദ്ധരിപ്പിക്കപ്പെടുകയാണ് എയുടെ മുന്നിൽ in front of the C that A is telling to B that he is the original owner even though C is the original owner and he is not contradictory to that statement. Nothing saying about that, not arguing that. Then if B is purchasing that goods from A, then C cannot acquire anything from B because in front of the B, who is the owner? A is the owner. So that is the title by Estoppel. So by the contact or by an act or the omission leads the buyer to believe that the seller has the authority to sell and induces the buyer to buy the goods, he shall be stopped from denying the fact of the want of authority of the seller. In such a case, the buyer gets a better title than that of the seller. Another example on A says to B in the presence of C that even though the real owner of the goods is C, A is telling to B that he is the original owner. So B, based on the wordings of A, B is taking that goods, then C doesn't have the authority to or acquire any part of that goods from B because in front of this one, in front of that, or B buys the goods from A, then C cannot recover the goods from B because he has let B. C is What is that? C is informing B that, or in front of B, or in front of this person, B is believing that A is the original owner. അതാണ് അവിടെ which was titled by Estoppel. Next is sale by a mercantile agent. So who is a mercantile agent? That already we see in the previous classes. In the agent, okay, fourth module, agent. Second is sale by a mercantile agent. Sale by a mercantile agent. Where the goods are sold by a mercantile agent who is in possession of the goods or any document of title to the goods with the consent of the real owner, and the sale is made in the ordinary course of business of a mercantile agent, the buyer will get a good title if he acts in good faith. ഉത്തമ വിശ്വാസത്തിലാണ് അവിടെ പ്രവർത്തിക്കുന്നതെങ്കിൽ the buyer will get a good title. So goods are sold by a mercantile agent who is in the possession of the goods. സാധനം പ്രോസസ് ചെയ്യുന്നതിന് അല്ലെങ്കിൽ കൈവശം വെക്കുന്നതിന്, okay, ownership അല്ല, possession only, or any document of title to the goods with the consent of the real owner, and the sale is made in the ordinary course of business of a mercantile agent, the buyer will get a good title if he acts in good faith. Following are the requirements for this rule to operate. The seller must be a mercantile agent. Seller ഒരു agent ആയിരിക്കണം. He must be in the possession of the goods or any document of the title to the goods with the consent of the real owner. Original owner ന്റെ സമ്മതത്തോടു കൂടി what the seller in a good possession of the goods or any document of title to the goods. ഒരു വേറൊരു വ്യക്തിയാണ് ഒറിജിനൽ ഓണർ എങ്കിൽ അയാളുടെ സമ്മതത്തോടു കൂടി വേണം ഈ സെല്ലർ കൈവശം വെക്കാനായിട്ട് സാധനങ്ങൾ, അല്ലെങ്കിൽ എന്താണ് ആ പർട്ടിക്കുലർ ഗുഡ്സിനുള്ള ടൈറ്റില് അല്ലെ ഡോക്യുമെന്റ് അത് കൈവശം വെക്കുന്നത്. Okay, so then only this to be done by a mercantile agent. Then the sale should be in the ordinary course of business. The buyer must act in good faith. ഉത്തമ വിശ്വാസത്തിലായിരിക്കണം ബയർ സാധനം മേടിക്കുന്നത്. പിന്നെ the buyer should not have at the time of the contract noticed that the seller has no authority to sell. The buyer should not have noticed that the seller has no authority to sell. വിൽക്കാനുള്ള അധികാരം അല്ലെ അവകാശം സെല്ലർക്ക് ഇല്ല എന്നുള്ള ഇത് ബയറിന് അറിയാൻ പാടില്ല എന്നുള്ള ഒരു കേസ് വേണം. At the time of the contract, the buyer should not have a notice that seller has no authority to sell. അയാളുടെ ഇതില് വന്നത് അപ്പോഴാണ്. Okay, so these are the cases with regard to a sale by a mercantile agent where these are the rules to be performed. The seller must be a mercantile agent. He must be in the possession of the goods or any document of the title to the goods with the consent of the real owner. The sale should be in the ordinary course of business, and the buyer must act in good faith, and the buyer should not have noticed that the seller has no authority to sell in case of or at the time of entering into the contract. So these are the case with regard to a sale by a mercantile agent. So title by Estoppel, then sale by a mercantile agent. Some exceptional to this rule. Sale by non-owners. Then third is sale by one of several joint owners. Sale by one of several joint owners. So what is that? If one of the several joint owners who is in sole possession of the goods by the permission of the other co-owners sells the goods, a buyer in good faith of those goods get a good title to the goods. So one of the several joint owners, പല ആൾക്കാരുണ്ട് അതിന് ഉടമസ്ഥൻ ഉണ്ടായിരിക്കും. So if one of the several joint owners who is in sole possession of the goods by the permission of the other co-owners, മറ്റ് കൂടെയുള്ള ബാക്കിയുള്ള ഉടമസ്ഥരുടെ സമ്മതത്തോടു കൂടി ഓരോ ഓണർ, ഓക്കെ, സെവറൽ ജോയിന്റ് ഓണേഴ്സിലെ ഒരാള് ഹു ഈസ് ഇൻ സോൾ പൊസഷൻ ഓഫ് ദ ഗുഡ്സ്, മൊത്തമായിട്ട് അയാൾ കൈവശം വെക്കുകയാണ് എങ്കിൽ, then if that owner sells the goods, then a buyer in good faith of those goods gets a good title to that goods. നല്ല ഒരു പേര് കിട്ടും ആ ഒരു ബയർക്ക്. So the co-owner must be in the sole possession of the goods with the consent of other co-owners. മറ്റ് സഹപ്രവർത്തകരുടെ സമ്മതത്തോടു കൂടി ആയിരിക്കണം ഇങ്ങനെ ഒറ്റ ഉടമസ്ഥാവകാശം വെക്കുന്നതെങ്കിൽ, ഉടമസ്ഥാവകാശമല്ല കൈവശാവകാശം വെക്കുന്നതെങ്കിൽ, then in such a case, the buyer in good faith of those goods can get good title for the possession of that goods. Okay, the buyer should purchase the goods for value and in good faith. ഉത്തമ വിശ്വാസത്തിനും മൂല്യത്തിനുമായിരിക്കണം buyer should purchase such goods. Then the buyer should not have notice at the time of sale of any defect in seller's authority to sell. At the time of the sale, വിൽക്കുന്ന സമയത്ത് ബയർക്ക് മനസ്സിലായില്ല അല്ലെങ്കിൽ നോട്ടീസ് ചെയ്യപ്പെട്ടില്ല that the seller has no authority to sell. Then in such a cases, what is that? Sale by one of the several joint owners in good faith, a buyer in good faith of such goods to be sold gets a good title to the goods. So this is the sale by one of several joint owners. Fourth point is sale by a person in possession under a voidable contract. Sale by a person in possession under a voidable contract. So what is that? Where a person in possession of the goods under a voidable contract sells such goods to another before the contract is cancelled, and the buyer purchases them for value in good faith and without notice of the seller's defect of title, he will acquire a good title. What is that? Where a person in possession of the goods under a voidable contract means not a valid contract. അങ്ങനെയുള്ള കേസിൽ where a person in possession of the goods under a voidable contract, there are chances to be void. അതാണ് sells such goods to another, where ഒരാൾക്ക് കൊടുക്കുന്നു, sells such goods to another before the contract is repudiated, cancelled, and the buyer in good faith purchases them for value and without notice of the seller's defect of title, അതായത് സെല്ലറിന്റെ ആ ഒരു ന്യൂനത അതായത് defect of the title of the goods, okay, then the buyer will acquire a good title to the particular goods. അതാണ് sale by a person in possession under a voidable contractന്റെ ബേസിൽ ഗുഡ്സിന്റെ പൊസഷൻ വെക്കുന്ന ഒരാളിൽ നിന്ന് മേടിക്കുകയാണെങ്കിൽ the buyer will get a good title to that. Then sale by a seller in possession after the sale, വിറ്റതിന് ശേഷം, okay, sale by a seller in possession after the sale. Fifth point. Where a seller having sold goods continues to be in possession of the goods or of the documents of title to the goods and sells them either himself or through a mercantile agent to a person who buys them in good faith and without notice of the previous sale, there also the buyer gets a good title. So how it is? Where a seller having sold goods with okay, continues to be in the possession of the goods or of the documents of the title to the goods, അതായത് വീണ്ടും ആ സെല്ലർ തന്നെ അതിന്റെ പൊസഷൻ കൈകാര്യം ചെയ്യുന്നു, ബയർക്ക് അത് കൊടുത്തിട്ടില്ല എങ്കിൽ, and sells them either himself or through a mercantile agent to a person who buys them. Okay, അവിടെ പറഞ്ഞ ഇത്രേ ഉള്ളൂ, continues to be in possession of the goods. വിറ്റ ഇതിനെ sold the goods, having sold the goods, continues to acquire the possession of the goods and of the documents that are belonging to that goods, documents of the title that are belonging to that goods, and sells them either himself, സ്വന്തമായിട്ട് തന്നെ വിൽക്കുക, അല്ലെങ്കിൽ through an agent to a person who buys them in good faith and without notice of the previous sale. മുന്നേ ഇങ്ങനെ വിറ്റതാണെന്നുള്ള ആ ഒരു അറിവില്ലാതെ the buyer in good faith purchases that thing, then he can get a good title for that particular good. That is the sale by a seller in possession after the sale. Then sale by a buyer in possession under an agreement. Sixth point. Sale by a buyer in possession after, so under an agreement. ഒരു എഗ്രിമെന്റിന്റെ സമയത്ത്. So sale by a buyer in possession under an agreement, where a person having agreed to buy the goods obtains with the consent of the seller the possession of the goods or of the documents of the title to the goods and sells them either himself or through an agent. The buyer who acts in good faith and without notice of any lien or other right of the original seller in respect of such goods gets a good title. അതായത് where a person having agreed to buy the goods, ഒരു വ്യക്തി സാധനം മേടിക്കുകയാണ്, obtains with the consent of the seller, with the consent of the seller, സമ്മതത്തോടു കൂടി possession of the goods or of the documents of title to the goods. Possession അല്ലെങ്കിൽ ആ ഡോക്യുമെന്റ്സ് ഗുഡ്സിന്റെ ടൈറ്റിലിനെ പേരിനെ ചൊല്ലിയുള്ള ഡോക്യുമെന്റ്സ് എന്തൊക്കെയാണ്. ഓക്കെ, ആൻഡ് സെൽസ് ദം എയ്തർ ഹിംസെൽഫ് ഓർ ത്രൂ ആൻ ഏജന്റ്. ഒന്നെങ്കിൽ അയാൾ തന്നെ വിൽക്കുവോ, ആ മേടിച്ച ബയർ തന്നെ വിൽക്കുവോ, അല്ലെങ്കിൽ ഒരു ഏജന്റിനെ കൊണ്ട് വിൽപ്പിക്കുവോ. ദെൻ ദ ബയർ ഹു ആക്ട്സ് ഇൻ ഗുഡ് ഫെയ്ത്ത്, ഉത്തമ വിശ്വാസത്തോടു കൂടി വാങ്ങിച്ച ആ വ്യക്തി, ആൻഡ് വിത്തൗട്ട് നോട്ടീസ് ഓഫ് എനി ലീൻ ഓർ അതർ റൈറ്റ് ഓഫ് ദ ഒറിജിനൽ സെല്ലർ. ഒറിജിനൽ സെല്ലർ ആരാണ്? മുന്നേ ഉള്ള സെല്ലർ. ഓക്കെ, അയാളുടെ ആ ഒരു ഇതിനെ അറിയാത്ത രീതിയിൽ ഇയാള് വിൽക്കുകയോ അല്ലെങ്കിൽ ഉത്തമ വിശ്വാസത്തെ വാങ്ങിക്കുകയോ ചെയ്യുകയാണെങ്കിൽ then that buyer will get a good title of that goods. So once again, where a person having agreed to buy the goods obtains with the consent of the original owner or seller the possession of the goods or the document of the title to the goods and sells them either himself or by an agent or through an agent, then the buyer who can act in good faith and without any notice of such a lien or the other right of the original seller, മറ്റേ ഒറിജിനൽ ആരാണ് വിൽക്കുന്ന ആളുടെ അവകാശം, ഓക്കെ, അത് ചോദ്യം ചെയ്യപ്പെടാതെ അല്ലെങ്കിൽ അറിയാതെ, and in utmost good faith he buys that thing, okay, then he can get a good title. So that is the sale by a buyer in possession under an agreement. ഒരു എഗ്രിമെന്റിന്റെ പുറത്ത് the sale by a buyer, വാങ്ങിച്ച ഒരു വ്യക്തിയുടെ വിൽപ്പന. ഓക്കെ, അതാണ് which one? Sixth point. And the seventh point, sale by an unpaid seller. Sale by an unpaid seller, where an unpaid seller who has exercised his right of lien or stoppage in transit resells the goods. വീണ്ടും അത് വിൽക്കുകയാണെങ്കിൽ the buyer can acquire a good title to the goods as against the original buyer. Okay, where an unpaid seller who has exercised his right of lien or what is that? The stoppage in transit, movement. Okay, stoppage in transit can resell such goods. The buyer acquires a good title to the goods as against the original buyer. ആ പുതിയതായിട്ട് വാങ്ങുന്ന വ്യക്തിക്ക് അതിന് ഒറിജിനൽ ബയർ ശരിയായ എന്ന് പറഞ്ഞാൽ ഇത് വാങ്ങിച്ച ഗുഡ്സ് പിന്നെയും വിൽക്കുകയാണ്. ഓക്കെ, ആ കേസാണ് നോക്കേണ്ടത്. സോ ഇൻ സച്ച് എ കേസ്, അങ്ങനെ വാങ്ങിക്കുന്ന ഒരു വ്യക്തി, the buyer can acquire good title to the goods as against the original buyer. ആദ്യം വാങ്ങിച്ച വ്യക്തിയെക്കാട്ടിലും രണ്ടാമത് വാങ്ങിച്ച വ്യക്തിക്ക് ആണ് എന്തുള്ളത്? Get the good title. And eighth point, exceptions provided under other acts. That is, sale by a finder of goods under certain circumstances is valid and the buyer would get a good title also. Sale by a finder of the goods, നമ്മൾ പഠിച്ചിട്ടുണ്ട് finder of the goods. Okay, ആരാണ് ഗുഡ്സിന്റെ യഥാർത്ഥ ഓണർ എന്നുള്ളത്, അല്ലെങ്കിൽ ഫൈൻഡർ കണ്ടുപിടിക്കുന്നതാണ്. Okay, under certain circumstances is valid and the buyer would get good title. Then sale by a pledge or a pony under certain circumstances, and sale by an official receiver or official assignee or the liquidator of a company is valid. So these are the exceptional cases with regard to a sale by non-owners. So today we see a sale by non-owners. So these are the exceptions. One is the title by Estoppel, another one is the sale by a mercantile agent, another one is the sale by one of several joint owners, another one is the sale by a person in possession under a voidable contract. Means not a valid one. Then sale by a seller in possession after the sale and sale by a buyer in possession under an agreement between these two people. Then sale by an unpaid seller, and also some of the exceptions under other acts like sale by a finder of goods under certain circumstances that it should be valid and the buyer would get a good title also. Then sale by a pledge or a pony that we see in the pledge, payment and pledge chapter. Okay. So sale by a pledge or a pony under the certain circumstances and sale by an official receiver or an official assignee or the liquidator of a company is to be valid. So these are the exceptional cases with regard to the sale by a non-owner. Clear? So this is to be dealt with the which one? What is the transfer of ownership? So we see in this chapter what is the transfer of ownership, and then transfer of ownership, then significance of the transfer of ownership, then rules relating to the or regarding the transfer of ownership, and what is or what are the rules with regard to a specific or ascertained goods or an unascertained goods or goods that has to be meant for sale or goods sold on approval basis. Then today we see goods sold on or sale by non-owners, യഥാർത്ഥ ഓണർ അല്ലാത്ത കേസിൽ. Okay, and some of the exceptional rules are these. So with that, we are going to conclude this chapter 3 or unit 3 of the fifth module. One more unit is there, performance of the contract of sale, means the last portion we will see in the later classes. So please have a look at today's classes and please clear your doubts as and when occurred. Please confirm after seeing the video after uploading. So thank you for the day.